Good morning, good afternoon, everyone. Welcome to today's webinar. Before I introduce our speaker, a brief house cleaning item. Some accrediting bodies allow non-sanctioned education hours. So if you'd like a certificate of participation for today's event, please email sales@bestnotes.com. That email again is sales@bestnotes.com. Now, it's my great pleasure to introduce Kim Stenger, who is a partner of Hullen and Hart in Boise, Idaho. Kim specializes in healthcare law, and he has kindly agreed to explain CFR 42 Part 2 to us today and address recent updates made earlier this year. If you have any questions for Kim, please enter them in the Q&A section of Zoom. Kim, thank you so much for your time today. Please take it away.
All right. Thanks, John. I appreciate it. I hope you all can hear me okay. We've got a lot to cover, so I'm going to go through this relatively fast. Quite frankly, I can't go through everything. And so in the slide materials here, I've given you some written resources, including links to the actual regulations, the commentary, the SAMHSA fact sheets that govern the Part 2 rule, and the like. If you do have any questions, in addition to using the chat feature, you can go ahead and email me at the link that's up there, and I'll try to respond offline. When we're talking about the confidentiality of substance use disorder records, remember it's not only Part 2. You've got the general statute that applies that really set the parameters. It was updated by the CARES Act, a couple of years ago, and we've been waiting for a couple of years to get the final rules that actually implemented the CARES Act provisions. And we finally just got that final rule. That's what we're going to talk about today. So in addition to the statute, you've got the Part 2 regulations, but you've also got to be concerned about HIPAA, the information blocking rule, and any other federal or state laws that may apply. Now, it's important when you're talking about these confidentiality rules that you remember that, they don't always line up. There could be conflicts between how these rules apply. Generally, when you're dealing with these conflicts in statutes, you've got to comply with the most restrictive state law. So where Part 2 is more restrictive, in most cases, Part 2 is more restrictive than HIPAA, you would have to comply with Part 2. If Part 2 doesn't cover it, then you would still have to comply with HIPAA. If there's another state or federal law that is more restrictive, then you would need to comply with that other more restrictive law. But we're going to focus today on the Part 2 regulations. As I mentioned, the CARES Act back in, I think it was around 2021, 2020, something like that, came out. And as part of that, the government, the legislature was concerned, Congress was concerned about kind of the conflicts between Part 2 and HIPAA. For any of you who tried to reconcile that, it's a mess. And so the CARES Act instructed SAMHSA or HHS to try to reconcile those two and to bring Part 2 and HIPAA together to coordinate those. And that's really what came out in the final rule. The final rule was issued February 8th. It's actually effective April 16th, I guess, yesterday. But the good news for you all is it's not enforced until February 16th, 2026. You've actually got 2 years lead time to get up to speed and to make sure that you're complying with these new rules. Now, that doesn't mean that you can necessarily postpone compliance because you still have to comply with the current Part 2 rules and you have to comply with HIPAA. So make sure that you're complying with the existing rules. This is probably the most important slide you'll see from me today. It's the highlights of what the new Part 2 rules do. Now, this isn't all of Part 2. This is just the new final rule, the changes that were made. Most importantly, it allows providers to obtain a single consent for all future uses and disclosures for treatment, payment, and healthcare operations, as those are defined under HIPAA. So it makes it a lot easier now. Instead of having to obtain a separate consent for each use or disclosure of SUD information, now you can get one consent that applies to all future uses and disclosures, but it's only limited to those treatment, payment, or healthcare operations purposes. It also allows HIPAA-covered entities and business associates that receive the records under such a consent to redisclose those records consistent with the HIPAA regulations. The theory there is, hey, HIPAA-covered entities and business associates, they're already covered by HIPAA, right? They've already got to comply with HIPAA, and therefore you can go ahead and they can redisclose so long as they're acting consistent with HIPAA. It modifies patient consent requirements. We'll talk about that. It requires a copy of the consent to be provided along with a notice of Part 2 obligations to recipients. So every time you make a disclosure consistent with the consent, you've got to provide a copy of the consent and the specific notice to those recipients that put them on notice that these records are governed by Part 2. It restricts the use of the records in civil, criminal, administrative proceedings against patients unless you've got either the patient consent or a court order. It adopts the HIPAA penalty structure and the HIPAA enforcement process rather than having a separate process under Part 2. It adopts the HIPAA breach notification requirements for Part 2 violations. It requires a new patient notice that's similar to the HIPAA notice of patient privacy, HIPAA privacy practices, and it adds a new complaint process for responding to Part 2 violations. All right, that's the general overview. Let's talk about the rules. So the whole basis for the Part 2 rules were the government wanted to encourage people to get substance use disorder treatment, but they were afraid that people were refusing to get it or were afraid to get it because of their records might become public, or they may be prosecuted or the like because of their participation, anything they admit in an SUD program. And so Congress enacted the Part 2 statute that generally says that any Part 2 programs, we'll talk about that in a minute, and certain recipients of substance use disorder records may not use or disclose that information that would identify that person as having had, or having been referred for a SUD, substance use disorder, unless the person provides written consent or an exception applies. And they strengthened in the new regulations, they strengthened the use or disclosure prohibition in civil or criminal administrative proceedings. A key here is, even though the Part 2 regulations always talk about SUD records are defined to mean not only the paper or electronic records themselves, but any information. So it's kind of like HIPAA. If it's any information, whether it's in recorded form or not, it's still covered by the Part 2 regulations, even though the Part 2 regulations refer to SUD records. What are the penalties if you fail to comply with Part 2? Well, under the old rules, there were criminal penalties. There was a misdemeanor for failing to comply. Under the new rules, they basically adopted the HIPAA penalties. For most of you, the most important ones are the civil penalties. You can get hit up with penalties of anywhere from $137 up to about $69,000 per violation if you don't act with willful neglect. If you do act with willful neglect, it's a mandatory penalty of about $14,000 to $69,000 per violation. You can also get hit up for criminal penalties, anywhere from $50,000 to $250,000, and anywhere from 1 to 10 years in prison if you improperly access or use that information, or actually if you improperly use or disclose the protected health information without authorization. So there are still criminal penalties, although those are relatively rare. The bottom line there is generally, hey, if you're a Part 2 entity, you got to comply with HIPAA. That's the gist of it. Under the new Part 2 regulations, they generally adopt the HIPAA enforcement process. So if there is a violation of Part 2, they can report you to OCR, and the OCR will do the investigation just like the HIPAA issues. You also have a breach reporting obligation, just like under HIPAA now. If you've got a violation of a Part 2 program, then you would have to report that under the standards that apply to the HIPAA breach reporting. All right. The key to Part 2 is understanding whether or not it applies to you. As far as the SUD information, as I mentioned, it generally applies to any information that identifies a patient as having had, or even if they didn't have it, if they were referred for substance use disorder, and if that information is created, received, or acquired by a federally assisted SUD program, then that triggers the Part 2, but it only applies if it comes through a federally assisted SUD program. We'll talk more about that in just a minute. But what is SUD? It's the cluster of cognitive, behavioral, and physiological symptoms indicating that the patient continues using the substance despite significant substance-related problems such as impaired control, social impairment, risky use, and pharmacological tolerance and withdrawal. So that's what SUD is. So the key here is determining whether or not you're a federally assisted program or you got records from a federally assisted program. Federally assisted, that's incredibly broad. If you're participating in federal programs or you're federally licensed, then you're probably going to be federally assisted. What really matters is whether or not you're a program within the meaning of the SUD regulations. That generally depends on whether or not you are affiliated with a general medical facility and whether you're holding yourself out as providing SUD diagnosis treatment. So, a general medical facility is like a hospital, an FQHC, a trauma center, maybe a group practice. It's more than just you, right? It's a general facility. The rules apply that if you are not in a part of a general medical facility, you are a program if you hold yourself out as providing SUD diagnosis, treatment, or referral for treatment, and you actually provide the SUD diagnosis, treatment, or referral treatment. On the other hand, if you are part of or affiliated with a general medical facility, then the program is either an identified unit within that program or certain medical personnel. If you're talking about an identified unit, if that identified unit holds itself out as providing SUD diagnosis, treatment, or referral, and it actually provides SUD diagnosis, treatment, or referral for treatment, then that identified unit within the facility is a Part 2 program. It can also apply to specific personnel. So if you've got specific personnel that work within a general medical facility, and those persons, that physician, counselor, whatever, if their primary function is to provide SUD diagnosis, treatment, or referral, and they are identified as such, then those medical personnel could be a Part 2 program, even though the rest of the general medical facility is not. The key there, or one of the keys, is whether or not they are holding themselves out as providing that SUD care. That is generally defined as an activity that would lead one to reasonably conclude that the individual or entity provides SUD diagnosis, treatment, or referral for treatment, for example, through advertising or marketing. In the SAMHSA FAQs, they give you some examples. For example, if you went through state licensing procedures to provide this type of care, if you are advertising or posting notices, you're providing certifications or show that you're providing certifications or obtain certifications in addiction medicine. If you're listing yourself in registries, internet statements, consultation activities for non-program practitioners, information presented to patients or families. If you're out there holding yourself out that, hey, we do SUD stuff, then you're probably going to be a program. A Part 2 program is not. If you're just an emergency room doctor and you happen to treat overdoses periodically, that doesn't make you an SUD program because you don't necessarily specialize in that and you're not holding yourself out as providing those types of services. As I mentioned, if you are the program, it's only the Part 2 program within a general facility that's covered by Part 2, right? So you have to isolate that Part 2 program. The rest of the facility is not necessarily a Part 2 program. So the Part 2 program part has to segregate or put in place protections to make sure that its Part 2 information is not shared inappropriately with the rest of the facility or the program or the organization. Well, so that's what a Part 2 program is. To whom does it apply? It not only applies to the Part 2 program, but the Part 2 rules also apply to certain recipients of that confidential information. So generally, the confidentiality requirements in Part 2 apply to not only the Part 2 program itself, but also entities with direct administrative control over the Part 2 program, qualified services organizations, and we'll talk about that in just a minute, lawful holders, which we'll talk about in just a minute, other persons who receive Part 2 information from a Part 2 program, covered entity, business associate, or intermediary, or lawful holder, but only if these other persons receive this notice of disclosure that accompanies the disclosure that puts them on notice that, hey, these are Part 2 programs. If they got that information and it puts them on notice that these are Part 2 records, then they've got to comply with it. An intermediary is basically a third party, like a healthcare database that receives these information. That's an intermediary for purposes of this. It applies to third party payers. Also, any person receiving SUD in a criminal administrative proceeding or the like, if they got notice that this information was coming from a Part 2 program. So one of the important things is Part 2 applies to QSO, or these qualified service organizations. QSOs are really just business associates under HIPAA, right? They're entities that provide certain services to a Part 2 program like data processing, collections alike. Part 2 says you can make these disclosures to these QSOs, but you've got to have a QSO agreement in place where basically that QSO agrees to comply with Part 2. It's similar to a business associate agreement. As amended by the new Part 2 regs, it confirms that a QSO includes business associates of a Part 2 program if that Part 2 program is a covered entity under HIPAA. So just realize that these QSOs, they're basically business associates, right? If you're a HIPAA covered entity, you're already familiar with those concepts, and you got to make sure that you've got this QSO agreement with those entities to whom you are disclosing that information to perform services on your behalf. The Part 2 rules also apply to lawful holders. A lawful holder is an entity, even if they're not a QSO, if they're an entity that's bound by Part 2 because they've received that SUD information pursuant to the written consent, plus they receive notice of the disclosure. So they get records, and those records are accompanied by a copy of the written consent plus a notice of disclosure alerting them saying, hey, these are Part 2 records. Therefore, you've got to comply with it. Now you are a lawful holder and you've got to comply with Part 2 with regard to those records. You're also a lawful holder if you receive those records under some of the circumstances where written consent is not required, like you're a QSO. Lawful holders may redisclose the SUD information, but their ability to, once they get those records, to redisclose that, you're limited by the Part 2 rules we'll talk about in just a minute. Now, if you're a non-Part 2 provider, so you're just like a general practitioner out there, and suddenly you get these SUD records, the government was somewhat concerned about, okay, what do you have to do with this? How do you protect those? And so the rules set forth the following rules. If you just get that information orally, you don't get a written record concerning a Part 2, then that non-Part 2 provider, they can record that information orally in their records, and their own records are not subject to Part 2. On the other hand, if they get those records in writing, then those records become Part 2, and they've got to protect those records. So they've got a couple of options. If they just put it in their general medical record, that means their general medical record now that contains that is going to be subject to Part 2. Alternatively, they can segregate those from the rest of the records, and they only have to protect the Part 2 records. The rest of the medical records would not be subject to the Part 2. If the bottom line is, if you are a non-Part 2 provider, then you probably want to segregate those written records if you get those, so that Part 2 doesn't apply to all of your records. Now, one of the important changes under the new rule, if you are a Part 2 program covered entity or business associate that receives the records based on a single consent for the disclosure for TPO, for treatment, payment, or healthcare purposes, in that situation, you're no longer required to segregate or segment such records. The theory there is, hey, if you're a Part 2 record or a Part 2 program, a covered entity or business associate, you got to comply with HIPAA and Part 2 anyway. So we're not going to require you to further segregate or segment those records because you've got to comply with Part 2 and or HIPAA anyway. So that makes it a little bit easier for you. All right, so that talks about what it applies to and to whom it applies. Let's talk about exactly what it requires. So it generally prohibits the use or disclosure of information, SUD information, whether or not it's recorded without the patient's consent, unless you obtain unless there's a particular exception that applies. It applies to any information concerning SUD treatment, not only whether the person actually had or currently has, but also even if they were referred for SUD treatment, even if it was later determined that they did not have it, then it still applies. It's a broad concept like PHI, right? It includes name, address, social security number, photos, or any other identifiable information relating to SUD. It does not include de-identified information under HIPAA. If you do have that information, any use or disclosure of the information must be limited to that information which is necessary to carry out the purpose of it. So if under Part 2, it would allow you to use or disclose that information, you still got to use the minimum necessary, just like the HIPAA minimum necessary standards. Those confidentiality requirements apply even if the person who you would otherwise make disclosure, even if somebody's coming and asking you about it, they already know that the person has it. It's like HIPAA, right? You still can't disclose it. It doesn't matter whether the other person already knows about it or has information. You still got to maintain the confidentiality. Even if you get the police or the court coming in and asking you for that information, you still can't disclose it and you still can't provide it unless they jump through certain hoops that we'll talk about briefly later. What about just, it even applies to simply responding to inquiries about a patient. So as a general rule, if you're a Part 2 program and you get a request, hey, is this person there? You can't disclose information in a way that would indicate that the person has an SUD program or was referred for an SUD program. So you generally can't disclose their presence in your facility if your facility is a Part 2 program that's identified as such, right? Because then identifying the person as in your program would identify them as having SUD, right? You could just acknowledge that they're in your facility so long as you're not a Part 2 or your facility is not identified as a Part 2 facility. Maybe just in a hospital, you could identify the person. Yes, this person's in the hospital, but you couldn't do it in a way that would show that they were in a specific SUD program. If you do get a request for that, for information, you can say, you can't even say that, hey, I can't disclose that to you because of Part 2, right? Because if that's the case, you're identifying that the person's a Part 2 program. You can say that we are limited in disclosing information. Here's some information about Part 2, but you can't acknowledge that this applies to this particular person. Now, the net effect is still the same, but nevertheless, the rules are there that you've got to respond in a way that doesn't affirmatively identify the person as having an SUD program. All right. So let's talk about disclosures of the SUD information. Most disclosures, you've got to have the patient's written consent. There are certain limited disclosures that you can apply, that you can make the disclosure without the patient's consent, but those are the exceptions, right? The general rule is you've got to have the patient's consent. That consent is pretty specific as to the elements that must be in an effective consent. I'm not going to go through all of those, but they're shown right there on those slides. They've got specific rules when you're identifying the recipient of the SUD information, because among other things, when you get the consent from the patient, you've got to identify to whom you are going to be making those disclosures. And so there are specific rules concerning how you identify those persons that apply depending on the type of the recipient. There are specific rules when it comes to counseling notes. Just like under HIPAA, there are special rules for psychotherapy notes. Same under Part 2 now as amended, there are special rules for counseling notes. Now, counseling notes like psychotherapy notes are a very, very limited set. It's basically those notes that a counselor would generate them for themselves to help them prepare the medical records. It's not the general SUD medical records, not that type of stuff. Generally, you can't disclose counseling notes unless you get a specific authorization that's limited to those counseling notes. Importantly, you generally can't disclose information, SUD information for use in any civil, criminal, administrative, or legislative investigation unless you've either got the patient's written consent or you get a Part 2 order from the court. We'll talk about that a little bit later. So they really strengthened the ability to for a court or another administrative entity to be able to access or use this information. Generally, you've got to have patient's written consent or an appropriate Part 2 order. Even though you've got this information, if you've got records pursuant to a consent, but you know that the consent is defective, it doesn't contain the required elements, or it's expired, or you know that it's been revoked, then you can't rely on it, similar to the HIPAA authorization rules. Now, if you are going to disclose information pursuant to, and you've got the patient's consent to go ahead and disclose this SUD information, the entity to whom you disclose that information, you've got to provide a copy of the consent that the patient gave you. This is a new rule. You've got to provide the entity to whom you are providing that information. You've got to give them a copy of the consent, and you've got to give them a required statement. The government has two different forms of the required statement that you can give them. There's the long form, or you can just give them the short form. I would actually probably give them the long form, because the long form explains to them what their obligations are, what that recipient is, what the recipient's obligations. So if you're going to be disclosing SUD information pursuant to the patient's consent, then you got to give them a copy of the consent, which sets forth the parameters of how they can use it and the basis for it. And you've got to give them a copy of this notice. Okay. Similarly, if you get records that are accompanied by a consent along with this notice, then you know that, okay, I gotta comply with part 2. All right, those now importantly, as I mentioned, the biggest benefit of these new rules is it allows you to get as a provider to go to the patient and get a single written consent for all uses or disclosures of for purposes of treatment payment or healthcare operations. As long as you get that consent, then if you're a Part 2 program, a covered entity, or business associate, you may use and disclose those records for purposes of treatment payment or healthcare operations that are otherwise permitted by HIPAA until the patient revokes such consent in writing. So it saves you from having to go back to the patient each time and get this consent. So this was an important factor. Now, the Part 2 program still has to comply with Part 2. If you're a covered entity and business associate, you still have to comply with HIPAA. So you can only use or disclose the information consistent with HIPAA requirements under treatment payment or healthcare operations. On the other hand, if you don't have that general TPO consent, if you just get the consent for a specific use that perhaps is not for treatment payment or healthcare operations, then the Part 2 program must limit any use or disclosure of the SUD information accordingly. There are limits. There are other rules that apply to like disclosures to central registries and disclosures in connection with criminal justice referrals and the like. Okay, so those are the general rules for if you're a provider and want to disclose the information. What about if you're a recipient of this Part 2 information? Can you use or disclose it further? I mean, you have to just keep it confidential yourself, or can you disclose it to further people? The rules are a little bit complex, and but it helps to understand, okay, who am I? Is the recipient going to be subject to HIPAA or the like? So the general rules are this. If the patient gives a written consent for the use or disclosure of their records, the recipient may further use or disclose the records as provided in Part 2 as follows. If those records were disclosed for treatment payment or healthcare operations to a covered entity or business associate, well, HIPAA applies in that situation. And therefore, that recipient may further use or disclose the records so long as they comply with HIPAA, right? The one exception to that is they can't use it for criminal, civil, administrative, or legislative proceedings without the patient's express written consent or court order. But generally, if you got those records, you're a HIPAA-covered entity or business associate, you got the consent that shows that it was for treatment payment or healthcare operations, you can further use or disclose that information for TPO purposes, just like HIPAA, just under HIPAA. On the other hand, if the information is disclosed for all treatment payment or healthcare activities, and that disclosure is made to a Part 2 program that's not a covered entity or business associate under HIPAA. So you may have a Part 2 program that's not covered by HIPAA. Maybe they don't engage in electronic transactions or whatever. In that situation, if they get that disclosure for treatment payment or healthcare operations, the recipient may further disclose those records consistent with the consent. So you'd have to look back at the consent. Again, the rules there, well, HIPAA doesn't apply to them because they're not a covered entity or a business associate. So you got to comply with Part 2 with regard to and you can only use the information consistent with the consent. If the records were disclosed to you for payment or healthcare operations to a lawful holder that is not a covered entity or business associate, so maybe it's some subcontractor or the like that you may want to redisclose this information to, that recipient may further disclose those records as necessary for its contractors, subcontractors, or legal representatives, like a subcontractor, carry out the payment or healthcare operation specified in the consent if certain conditions are satisfied. So this is a situation where you're disclosing that information, or you receive that information. You're not covered by HIPAA, but now you've got this information, right? You can only further disclose it to others if essentially you can disclose it to your subcontractors to help fulfill your obligations, but you've got to get an agreement with them that they're going to comply with Part 2 regulations. It's kind of like under HIPAA. If you disclose it to a business associate, that business associate can further disclose it, but only if they get a subcontractor business associate in place. That's kind of the same concept here. You just have to get this further assurance that they're going to comply with those rules. All right. There are exceptions that allow you to make disclosures to prescription drug monitoring programs, so long as you've got the patient consent. But just simply because the state law requires you to make that disclosure isn't enough, because Part 2 will trump contrary state law, so you'd still have to get the patient consent. So probably what you're going to want to do when you get the patient showing up at your facility, you're going to go on and have them sign a consent that allows you to make those disclosures for the prescription drug monitoring program. It allows you to make disclosures to prevent multiple enrollments. So if there's like a database that allows providers to go in there and check and make sure that people aren't, getting too many prescription drugs and those types of things, you can participate in those registry programs as long as you get the patient's consent and you satisfy certain requirements. And there are there's an exception that allows you to make disclosures for criminal justice system as long as you get the patient's consent and you limit the ability for disclosure to those who are limited to know. So this may be a situation where the court sends the patient to a drug monitor program or a court-approved program. Then you can go ahead and make those disclosures so long as you get the patient's written consent and you limit the disclosures to those who need to know. All right, those are the rules applying if you've got the patient consent, right? Situations where the patient gave you consent, you can go ahead and make those disclosures and in certain circumstances, redisclose that information. Let's talk about the exceptions that go ahead and allow a Part 2 program to make disclosures without the patient's consent. Well, you can make the disclosures within the Part 2 program based on a need to know, but it has to be a need to know, kind of like HIPAA. You can also make communications between a Part 2 program and the entity with direct administrative control over the program. You can also make the communications with the QSO, but you've got to have that QSO agreement, like a business associate agreement. You can make reports to law enforcement for crime or threats that are on the program premises or that are against program personnel. So you don't have to, allow the people to beat you up and you can't report it to law enforcement. You can go ahead and report it, but you've got to limit the information to the circumstances of the incident. Okay. You can disclose the information to report child abuse or neglect consistent with state law, but you can report the neglect, but you can't actually turn over the SUD records without additional, them jumping through additional hoops. You can make disclosures if there's a bona fide medical emergency, but only if there's not available time or ability to get the patient's written consent. Even in those situations, you've got to immediately following that disclosure, you've got to document the disclosure in the medical record, including to whom you made the disclosure, their affiliation with the facility, and certain other information. You can make disclosures as part of a Part 2 program audit. So the government or a third-party payers coming in, but the rules differ depending on whether or not they're going to come in and perform the audit on your site or whether they're going to remove the records away from your facility. Just make sure you check those rules. And you'll probably want to make sure as part of your TPO consent that it would include those types of auditing functions. There's different rules depending on whether or not you got that TPO consent. So there's, as I mentioned, under the statute, you cannot use SUD records in any federal or state civil, criminal, or administrative proceeding, investigation, or action unless you have either the patient's consent or an appropriate court order. If you're going to get court order to release SUD information, it's a special kind of court order. It's not just your regular warrant. It's not just your regular court order. In order for this to be enforceable and for you to comply with it, it's got to be a court order signed by the court, plus it has to be accompanied by a specific subpoena. And the judge can only issue those if they've satisfied certain standards and have gone through certain administrative proceedings. The bottom line here is if you get the police just showing up and asking you for information, or even showing up with just a garden variety warrant, or you get a subpoena from a third party requesting the information, you cannot disclose that. You have to respond in a way so that would tell them that, no, you've got to jump through these hoops before we can disclose any information. Now, how you do that without, acknowledging that the person's an SUD person, well, there it is. But the gist of it is still the same. You would have to tell them that that you require the particular type of order. All right, let's talk briefly about minors. So Part 2 applies to minors, right? But it generally depends on whether or not, under your particular state law, whether the minor can consent to their own care for SUD treatment. If the minor under your state law, if your state law allows the minor to consent to their own SUD care, then that minor controls the disclosure of their SUD information. You can't disclose that information without the minor's consent, including disclosures for payment purposes. So under HIPAA, it would allow you to use or disclose information for payment purposes, even if the patient doesn't consent, so long as you haven't agreed otherwise. That's not the rule for SUD. Under SUD, you can't even use or disclose the information for payment purposes unless the minor consents. Now, it does confirm that you don't have to provide care, right, unless the minor does consent. So if you have that minor showing up, say, okay, we need this consent to use or disclose it for treatment, payment, or healthcare operations. We're not going to provide care for you because we expect to be paid. Okay. On the other hand, if under your particular state law, minors may not consent to their own SUD treatment, like Idaho just passed a new law that minors can't consent to their own treatment now. So because of that, under those situations, then generally state law controls, but HIPAA has, or Part 2 has a twist. So if that minor patient shows up and wants the information, they can't consent to their own, or wants to get care, they can't consent to their own care under Part 2. So you'd still need to get parental consent before you can provide the care. But under Part 2, you can't disclose the patient's application for the care. You can't tell the parent that, hey, this kid showed up and requested care. You can't make that disclosure to the parent unless the minor consents. So you can't even disclose that application. So be careful about that. There is the limited situation if you determine that the minor lacks capacity to make rational decisions, then you could go ahead and reach out to the parent. Otherwise, you need the minor's consent to reach out to the parent to get consent to provide the care, and presumably to provide the disclosure for treatment and the like. In those situations, even in those situations, even though you got parental consent, if you're going to make further disclosure, you've still got to get consent for those further disclosures, not only from the parent, but also from the minor, which can make it problematic. Okay. The key there is to make sure you get that appropriate consent. And if they're not going to give you that appropriate consent, then you can terminate appropriate care. You may disclose facts relevant to a substantial threat to the minor or to another person by the minor, if the minor lacks capacity to make rational decisions due to their age or mental or physical condition, and the disclosure may reduce substantial threat to well-being or of the minor or the person to the physician or the other person. So that's the rules for minors. What about adults? Under adults, if the patient lacks capacity, then you can disclose information to and pursuant to the personal representative. But unlike HIPAA, which, that depends on the person's capacity under state law, under Part 2, you can only determine that the person lacks capacity if they've gone to court and the court has determined that the person lacks capacity. Just having a personal representative show up and say that they lack capacity, or you making that internal determination that they lack capacity, isn't sufficient. You've actually got to get a court order. Short of that, then you can't make those further disclosures. If the court has not determined that the adult patient lacks capacity to make their own healthcare decisions, the Part 2 does give you one out that allows you to at least get care or get paid for the care that you're providing. In that situation, it allows the Part 2 program director to consent for the disclosure for the sole purposes of obtaining payment from a third party. Otherwise, you would be limited in your ability to make disclosures. What about deceased persons? Well, just because the deceased person dies doesn't mean Part 2 goes away. Generally, you'd need to get consent from the authorized personal representative of the estate in order to make those disclosures. There is an exception that does allow you to disclose cause of death consistent with state laws for reporting vital statistics. Generally, for other disclosures, you need the consent from the patient's personal representative. All right. The new Part 2 rule does reaffirm certain patient rights. When it comes to ID cards, you can't require a patient to carry ID cards away from your facility. You could require them to carry it within your facility, but not away from your facility. Just like under HIPAA, a patient, well, actually under Part 2, the patient does not have a right to access their information, but because HIPAA also applies if you're a Part 2 program, then under HIPAA, then you would the patient generally does have a right to access their protected health information that's maintained in the designated record set with certain limited exceptions. A patient, just like under HIPAA, a patient does have a right to request uses or disclosures of their information for purposes of treatment, payment, or healthcare operations, right? So you can go ask the patient for a consent for use or disclosure for treatment, payment, or healthcare operations. That patient has a right to decline it. Okay, if they decline it, then you can't use it for that unless you get a specific consent later on. On the other hand, if they say, "Oh yeah, you can go ahead and use it, but I want you to limit the use or disclosure for treatment, payment, or healthcare operations to these particular situations," again, you're not required to agree to those restrictions, but if you do agree to those restrictions, then you've got to comply with those restrictions. If you don't agree to some of those restrictions, I'm not sure why the patient would give you consent for use or disclosure for TPO anyway, but nevertheless, there you go. That's the rule. There is one limited exception to that, just like under HIPAA, if the patient pays for the episode of care themselves, then they have a right to limit your use or disclosure for treatment, payment, or healthcare operations if the disclosure is for payment purposes to a third-party payer, just like under HIPAA. Just like under HIPAA, the patient has a right to get an accounting of disclosures that you made of their information. It's basically the same HIPAA rules. Even if you're not covered by HIPAA, but you're a Part 2 program, then you still have to comply with these accounting rules. An important difference is under the Part 2 rules, if you're maintaining electronic protected health information, these rules allow the patient to get a disclosure of or an accounting of disclosures you've made under an electronic health record system for disclosures made during the prior 3 years. That's even if it's for treatment, payment, or healthcare operations. That's different than the current HIPAA rule. Now, but with that said, when they implemented these Part 2 regulations, they say, okay, these are Part 2 regulations, but you don't have to comply with that accounting for treatment, payment, and healthcare operations until HHS has issued the regulations under HIPAA, corresponding regulations under HIPAA. So just watch for that coming down the road. As I mentioned, an intermediary is a special beast under the Part 2 rules. It's an entity or a person other than a Part 2 program covered entity or business associate who has received records under a general designation and a written patient consent to be disclosed to one or more of its member participants who has a treating provider relationship with the patient, like a health information database, data exchange, something like that. If the patient can go ahead and consent to allow those disclosures to be made to that database, that's fine under the TPO exception or under a specific consent. But if that intermediary receives a request from the patient to make a disclosure, that intermediary has to provide patients with a list of persons to whom the patient's records have been disclosed within the last 3 years. And there's additional specific regulations governing that intermediary's obligations in those situations. Under the new rules, the Part 2 program has to have a process for receiving and responding to complaints. The person has the right to file a complaint with HHS in the same manner the person may file a HIPAA complaint. The Part 2 program may not intimidate, threaten, or coerce, discriminate, or retaliate against a patient for asserting their Part 2 rights, including filing a complaint. And the Part 2 program may not require the patient to waive their right to file a complaint. You can't say, hey, we'll provide treatment only if you waive your Part 2 rights. That doesn't work. Under the new Part 2 rules, they require you, when you first provide care, if you're a Part 2 program, you've got to provide a notice to the patient of their rights, including informing them of the federal laws, give them a copy of the patient's notice of privacy, of your notice of privacy practices. So if you are a Part 2 program, you're going to have to develop a new notice of privacy practices. It's similar to, but contains a lot more information than is maintained in the current HIPAA notice of privacy practices. So you're going to have to update your HIPAA notice of privacy practices to incorporate these new requirements. I'm not going to go through these, but just realize that that those requirements are in the rules. So before February of 2026, you're going to want to amend your notice of privacy practices to include those new requirements. Don't do it now, because if you do it now, then you're going to be governed by that for the next 2 years, right? Do it just before February 2026. All right. when it comes to that, providing that notice of privacy practices, you've got to make that notice available to the person or the patient upon request. In addition, you've got to affirmatively provide that notice no later than the first service time that you provided service. If that's in person, you provide it at that time. If you communicate with the patient via email or the like, provide that service via email, then you've got to set it up so that you provide that electronically back to the patient. If it's an emergency situation where you're providing care, then you got to provide it as soon as the emergency is over. If you maintain a physical delivery site, then you've got to post that notice of privacy practices at your physical delivery site, just like HIPAA requires. If you maintain a website, you've got to post that notice on your website and make it available through the website. You may provide that notice or a copy of that notice to the patient via email as long as you get the patient's consent. You've got to provide a paper copy of that notice if the patient requests a paper copy. Under the CARES Act, it includes a bunch of additional anti-discrimination provisions, but under these final Part 2 rules, they didn't address those. They said that we're going to put off implementing or coming up with the anti-discrimination provisions as yet. So even though these anti-discrimination provisions appear in the statute, we don't have the implementing regulations right now, so I wouldn't be too overly concerned with those. Let's talk briefly about the security rules. The regulations state the Part 2 programs and lawful holders must have formal policies and procedures to protect against the unauthorized use or disclosure of SUD information or threats to the security of SUD information. For purposes of Part 2, under HIPAA, you think of security applying to EPHI. Under Part 2, security applies to any forms of SUD information, whether it's paper or whether it's electronic. And it requires that any Part 2 program or any lawful holder, so even those recipients, if you're a recipient of that Part 2 program, you still got to have these policies. Now, it's not as draconian as the HIPAA security rules or those types of things, but you've got to have policies to receive and protect this information, including policies addressing transferring and moving records, destroying records, maintaining records in the secure room, cabinets, or facilities, using and accessing workstations, rooms, cabinets, or facilities, de-identifying records consistent with HIPAA standards. Note that this applies to those lawful holders. I mean, you're sitting there minding your own business, and suddenly you get these Part 2 records, and now you've got to make sure that you've got policies in place to protect this information, right? If you don't want that, I guess what you do is send back those records and say, we don't want to have anything to do with this, right? But if you are a recipient of that, then you've got to comply with that. Now, the exception is those standards, the requirements for those policies do not apply to family, friends, or other informal caregivers who are lawful holders because they receive that information pursuant to the consent along with that notice. But the government doesn't expect, mom and dad to put in place these formal policies. Even though Part 2 does not have formal, cybersecurity rules, those types of things, most Part 2 programs are still going to be covered by HIPAA, and therefore you still got to comply with the HIPAA security rules. If there is a breach of your Part 2 information, then under the new Part 2 rules, you've got to notify the individual and HHS if there is a breach of unsecured information, just like you would if you were covered by HIPAA. So under HIPAA, you've got to do it if you're a covered entity or business associate. Even if you're not covered by HIPAA, if you're a Part 2 program, then you still got to comply with the breach notification rules. If the Part 2 program's taken over by another entity or it ceases to operate, then there are specific rules about how you dispose of those records. You can't just turn them over to the new entity. All right, that is a brief summary of the rules. I'll take just a couple of minutes to give you kind of a checklist, my checklist of the things that you need to make sure that you're going to do between now and February 26th of 2026 or February 16th of 2026. The first thing is don't think that you don't have to do anything, right? Because even though the final rule doesn't take place, the current rules are still in effect, and you still got to comply with HIPAA. So make sure that you understand the Part 2 rules and that you are complying currently. You need to determine if and to what extent you are a Part 2 program, a QSA, a lawful holder, or otherwise covered by Part 2 so that you can put in place the relevant rules, including if you just receive notice of, you receive SUD records along with that notice. You should determine if and to what extent you have relationships with QSOs, intermediaries, lawful holders, and other entities that must be considered so that you can put in place processes to make sure that you are maintaining the complying with Part 2 as you transfer these records over. You need to review and, if needed, modify your process for disclosures of SUD information within and outside your organization. You need to identify, draft, and execute qualified service organization agreements with your QSOs, business associates, because they are now by definition QSOs if you're a covered entity or business associate. And that's going to require you to likely review and modify your existing HIPAA business associate agreements. You're going to require, it may require you to review or negotiate, train, or terminate current business associate relationships. So if your current business associates are not going to comply with the Part 2 rules and you're a Part 2 provider, then you may need to terminate or modify your arrangements. You need to review and, if necessary, update your security risk assessment to consider your Part 2 obligations. Remember, because HIPAA also says, right, that to the extent that you are covered by a more restrictive state law or federal law, then HIPAA requires that you comply with that as part of HIPAA. So as part of HIPAA, you're going to need to make sure that your Part 2 rules, that your systems are consistent with Part 2. Otherwise, you're going to not only be in violation of Part 2, but also in violation of HIPAA. So you're going to probably want to review and update your privacy and security policies, ensure compliance with the Part 2 policy requirements, including the disposal of SUD information, ensure you have an effective cybersecurity protections. As you get closer to February of 2016, you can always go ahead and implement this now if you want to. It's just it doesn't become effective until February 2016. In fact, in some cases, you may actually want to implement this now so that you can rely on the TPO exceptions and those types of things. So if that's the case, if you do want to implement that now, then you want to put in place these new consents, and you'll want to put in place your new notice of privacy practices that governs how you're doing that stuff right now. So you're going to want to draft and implement your new patient consent forms, make sure that it contains the required elements that are in Part 2. So crack Part 2 and go down the checklist. It should make sure that you authorize the use and disclosure of TPO, because that'll make your life a lot easier. Even though you've got existing patients in your facility, you may want to make sure or ask them to sign this new consent form. Again, they're not required to, but I would ask them to sign the new consent form that deals with TPO. You're going to want to review and update your notice to recipients that accompanies those disclosures. Remember, every time you disclose with the patient's consent, you've also got to give that notice, and that was updated under the new Part 2. So you'll probably want to incorporate that new notice requirement when you make those disclosures. You're going to want to draft your new notice of confidentiality rights, that notice of privacy practices, make sure that it contains the required elements. You're going to want to review, draft, and implement your policies concerning the patient rights, including make sure you've got your complaint process, address the patient's right to access information, request restrictions on the use or disclosures for purposes of treatment, payment, or healthcare operations to the extent the patient consents to that, accounting of disclosures, especially if you have an electronic record system, although you don't need to be too worried about that until HHS issues its regulations under HIPAA. You're going to want to train your staff concerning all of those particular items. And there you go. That will probably keep you fairly busy over the next little bit. If you want, looking for additional resources, actually just yesterday, the OCR and SAMHSA just published a new webinar dealing with these new Final 2 rules. I have not had an opportunity to look at that. If SAMHSA says anything that's contrary to what I said, then probably defer to what SAMHSA says. But you may want to take a look at those rules or that webinar. You can access that at the link on my website there. SAMHSA has a bunch of resources available on its website dealing with Part 2. Now, because OCR is responsible for enforcing Part 2 compliance, OCR has added additional Part 2 information on its website. You can access it at that link up there. In addition, we've got additional resources on our website that you can go to and access for free, including things on HIPAA, webinars concerning Part 2, and the like. All right, that is it. Probably more than you wanted to know, and not everything you should know, but hopefully gives you a pretty good idea of what's going on with the new regulations. John, do you want to
Thank you.
step in and add or correct or say
No,
anything else?
that was like you said, there's a lot to think about there. Thank you for laying it all out for us. Anybody have any questions for Kim?
And like I said, you can ask him now, or if you want to wait and shoot me an email, you can do that offline too.
Kim, I'm curious, What are the common mistakes your clients make with part two?
Um, I think initially it's assuming that they're covered by part two when they're really not. Um, I would not undertake part two obligations if you really don't need to. Now, if you are, then you are, and you better darn well comply. Um, I think that a lot of clients don't realize that even if they're not a part two program, if they're a lawful holder, if they get that consent plus the notice that they've got to comply with that, they don't understand what that means. And so part of that is education. If you're a part two program, you may want to educate those people to whom you are given the information. If you give them more extended notice that goes along with the disclosure, then that'll go a long way in advising them. As a part two program, right, you're not required to monitor the recipient's compliance. You don't care too much about that. As long as you gave them the consent and you gave them that notice, then you should be okay.
That's sage advice.
All right. I think that, oh, we've still got a couple more minutes. Any other questions? All right. Should we go ahead and wrap it up, John? And let's,
One question just slipped through. Stacy
okay.
asks if a minor SUD patient requests their own records, are we allowed to notify their parents? They're in Utah, if that is any help.
So it depends on Utah law whether or not Utah would allow the minor to consent to their own health care. Minors probably have a right to access their own records. Um, and you can't notify the parents about any of the SUD information if the minor can consent to their own health care under Utah law. If the minor can't consent to their own health care under Utah law, then you would, any disclosure to the parents would require the minor's consent also.
Makes sense. Yeah, thank you.
Well, whether it makes sense or not, that's the rule. Sometimes I wonder about this stuff. It
Yeah.
is pretty complicated because,
Yeah.
in fact, it's some of the most complicated regulations I deal with because you've got these layers between HIPAA and Part Two, and they did try to coordinate the two, but it's not done in a very cogent manner. It's not a very user friendly manner, and so you've got to kind of weed through those issues.
Well said. And like I mentioned in the chat, your slide presentation is an excellent resource. And Kim gave us permission to share these slides. And of course, if you want to get in contact with Kim, his email's on the screen, also in the chat. Kim, can't thank you enough for your time. Thank you so much.
Happy to do it. Good luck out there.
Cheers. See y'all.